The California Family Code contains numerous community property rules. Those rules come into effect when spouses legally marry, at which point the spouses are considered an economic community. That economic community continues until the marriage's dissolution or the death of a spouse. Because the community property rules apply only if a valid marriage exists, a threshold question is whether there's a valid marriage. The 14th Amendment to the United States Constitution is construed to protect a fundamental right to marry a person of one's choosing. Consequently, there are some boundaries on state regulation of marriage. But generally speaking, states may impose requirements and restrictions on marriage provided that they don't directly and substantially burden the right to marry. California, like all states, imposes certain restrictions on capacity to marry and requires compliance with certain formalities. Under California law, marriage is a civil contract between two persons. Capacity to marry refers to each person's legal ability to consent to that contract. Generally, to have capacity, a person must be 18 years of age or older and be presently unmarried. A person under 18 has capacity only if the person obtains a court order and written permission from at least one parent or legal guardian. Additionally, to have capacity, a person must be of sound mind and not be under the influence of alcohol or narcotics at the time the marriage is solemnized. Certain types of marriages are expressly prohibited. Parties can't validly consent to such marriages. Prohibited marriages include incestuous marriages and bigamous marriages. Incestuous marriages are marriages between close family members, such as between parents and children, full or half siblings, or aunts and uncles and nieces and nephews.